Thank you, Chairman Langford. Today's hearing continues our subcommittee's examination of the overall topic of federal regulatory policy. I look forward to hearing from both of our witnesses today on judicial review of the regulatory process and how to best approach that review. It's critical that Congress continues to review how federal agencies operate, as well as how Congress interacts as a body with other branches of government. This is especially true on the issue of regulation, regulation today that touches every facet of our society. In examining this issue, I think it's critically important to take a look at our current system. In the regulatory process, which has matured over time, legislative action and judicial review, are those processes flexible enough to handle most circumstances? Does it offer fair consideration to concerns of business and everyday Americans? Does Congress and the administration, both of which are elected by and responsible to the people, maintain that critical role in advancement of regulation? Those are just some of the fundamental questions we have to consider anytime we delve into reforming our regulatory process. Our nation needs both effective and efficient regulation. Obviously, a huge part of that regulation is what happens after those regulations are promulgated and how do we best have a system of analyzing and reviewing regulation. And as we talk about judicial review, one thing that we have forgotten is that once regulations are promulgated, nothing prevents the Congress from also responding if in fact the will of the Congress is not done. And so I think all too often Congress abrogates its responsibility on oversight of regulation to the judiciary, creating further uncertainty and a lack of ability to actually respond, leaving it up to the judiciary. I think today we're in exactly that situation with King v. Burwell. And so I look forward to this testimony. I think that this is incredibly important, and as somebody who, as a lawyer, practiced in this area, I look forward to hearing the shortened version of your testimony, and I want to congratulate you both before we begin at the high quality of the work that was done on behalf of this committee and in preparing for this testimony. So thank you, Mr. Chairman, for introducing this important subject, and I look forward to the testimony. Thank you, Mr. Chairman. A very complicated history and a very long history, and how you look at this, unfortunately, frequently is through maybe too political of a lens than what it should be, as we're kind of looking at predictability. And one of the concerns that I have is that we are focused on, in this discussion, on judicial review. Why is judicial review necessary if, in fact, the agency makes a mistake? Congress plays a role in correcting agency mistakes, it seems to me. And that's one thing that if you're on the court and you're trying to figure out what congressional intent was and whether in fact congressional intent was followed through these kind of interpretive rules or rulemaking process, you must be extraordinarily frustrated thinking, why can't Congress clean up their own mess? Why do we have to do it? And I think that's one of the frustrations that I have in all of this. I think many times the issues that are deferred to the agency are issues that are too controversial or too difficult for Congress to decide themselves. And I'm going to build on the chairman's example, Waters of the United States. We recently had a hearing in the Agricultural Committee to talk about waters of the United States. And I asked a simple question. What are waters? After a lot of critique about that rule and about the rulemaking process, I asked a simple question, which was, what are waters of the United States? Not one person could offer an answer. It's incredibly complicated, and you know, I'm not pleased with the process that was used and the controversy around that rule, but I am sympathetic that frequently this body spends way too much time, you know, kicking the can down the road by providing, by taking something that's very controversial and putting it in the lap of the agency as opposed to doing our due diligence and our responsibility. But I want to talk a little bit about interpretive rules because it has become kind of the buzzword for agency overreach. And having been involved in an earlier life in the tax world, I guess I would ask you, Mr. Grossman, do you think IRS letter rulings should be subject to rulemaking standards?
I think the answer is yes, to the extent that they are going to be given any greater degree of deference than Skidmore deference. That said, I think an IRS letter ruling, given the way that the tax code is structured, is something that in most instances, not all instances, but most instances, is something that's going to hold up.
Are you concerned at all with that answer? Are you concerned at all that it will, in fact, even further delay certainty to a businessman who simply says, I want to know if I do this, what the long-term tax treatment will be? And I understand that you might be doing saying things that could be more broadly applied and representing your interpretive rule, but I need this answer today, not 3 years from now.
Yes, Senator, I certainly do take into account that concern, and it is a real and a legitimate one. I think I would have two responses to that. One is to identify with your earlier remarks that a lot of these areas where there is uncertainty in the law is due to either complexity wrought by Congress or to vagueness or ambiguity wrought by Congress. The tax code, I think, is a capital example of that in terms of its complexity. Second, Congress can, in some instances, affect the way legitimately that judicial review and deference is operational. If Congress decides that certain types of tax rulings are entitled to a greater degree of deference to promote certainty, that's fine. That's something that Congress has the authority to do. That doesn't necessarily mean that it needs to be the case across the board. I think that's a policy issue for Congress to decide.
I think one of the concerns that I have about all of this is where we have burdensome and unnecessary regulation, we also have delay in providing regulatory certainty. And that delay could be further extended if we, in fact, look at every instance of interpretation of a statute as being subject to the rulemaking process. Wouldn't you agree that we would have, we could have the potential of actually delaying critical certainty if we expand the way you're suggesting we expand the definition of what constitutes a rule subject to rulemaking?
No, actually, I would not agree with that. And the reason is because the rules that, litigation, when a court applies a particular standard of deference, a standard of review, really applies to relatively very few cases, and it sets the rules and the framework that an agency works under going forward and that governs people going forward. And so when there are understandings of the way that statutes work and the way that courts are going to resolve them, it's actually very few cases, very few interpretations and very few instances that are involved in legal controversies. Yeah. It's the tip of the iceberg.
Mr. Levin, what would be your response to my question?
I think I would agree with what I took to be the thrust of your question, which is that people need guidance. And they have questions in their mind. They want to know where the agency stands. They don't want to wait for an agency to conduct an entire notice and comment proceeding in order to get an answer. They want an answer immediately. Agencies will respond by putting out informal statements that say, here is the position we would take. You're not bound by it, but at least you know what our position is. If we were to say that, that those statements have to go through the notice and comment process, you'd see many fewer of them, and that would be less responsive to the public's need for an understanding of what the agency's position is, and oftentimes they don't want to fight it, they just want an answer. If you were to say, well, those statements can be issued, but they have no weight because the courts won't defer to them, then the recipient of the advice would say, well, this doesn't do anything for me because I haven't gotten any
It's kind of
answer. Worthless. Right, so if I can only trust what comes out through the notice and comment process, it's saying I can't trust what the agency told me. And if you're hostile to the agency, you'd say that's great because they won't get deference, but if you just want an answer, you want to know how can I conduct my business in a way that the agency will not challenge, then it's not good news.
And not to not to delay it, but controversial opinions or controversial decisions from agencies can always be reviewed by Congress. We know what they are, but there's a reason why controversy exists, and frequently this body is the most at fault for not providing certainty in terms of direction to agencies. Taken that that is, kind of the problem, that politically, and let's at least acknowledge that the president is politically accountable for decisions that he makes, maybe not in his second term, but he is politically accountable and has an obligation to listen to what people believe, and we all go there. But the solution of turfing this or making the court the ultimate arbitrator of these decisions has its own limitations. And I think it's interesting that the two cases that we're talking about today, direct regulations that we've referenced, which is Waters of the United States and clean coal, the EPA CO2 regulation, both of those situations are presented because of Supreme Court decisions. So you already had a review process that may not necessarily have dealt with deference, especially on CO2, because the question was EPA had decided not to regulate CO2, and the court reversed that decision and said, yes, you have jurisdiction to regulate CO2. And that began this process that we're in. When you look at the opinions in Waters of the United States, you have 4 deciding that EPA is wrong, you have 4 deciding EPA is right, and you have a decider in the middle who said, well, I'm going to side with the 4 that said EPA is wrong, but I think you ought to maybe think about doing it this way. And so there's huge uncertainty that's created, and ironically, in those 2 cases, created because of Supreme Court decisions. And so, I understand and appreciate the concern. I'm as vehement about Waters of the United States and CO2 regulation as anyone on this panel. But I think that we are asking to put a really heavy burden on the courts when, as Senator Peters was talking, courts are ill-equipped at this point, just in terms of resources, to play that role. And is that what role does the court have in all of this? And we're really talking about a standard because should it be Chevron deference or our deference or whatever it is? At the end of the day, what capacity does the court have, I think, is the question, either in terms of resources or ability, especially given, the 2 examples we're having here where the court didn't provide additional clarity, in fact, may have made it even more difficult to find clarity.
And again, I would like to jump back in. And what happens when it's not the court, but behind closed doors, when settlements are made?
Yeah,
where does that fit into this?
And that's a problem, Senator, regardless of who's, it could be corporate America behind a closed door, it could be the environmentalists behind a closed door. I'm always concerned about friendly lawsuits that make a policy decision and say, now we're enforcing a consent decree and not interpreting a statute. And I guess, Mr. Levin, it'd be interesting to hear your perspective on the friendly lawsuit, possibility.
The question's been kicking around for a long time. And one of the problems is a lack of clear factual information about the extent of any abuse. And it is often the subject of heated charges in both directions. But I would say that Congress should be careful in this area and develop a clear factual basis for any action it might take.
But do you share our concern that this, in fact, could happen and maybe has happened in the past?
It could, but I think the number of accusations exceeds the number of ones that can be substantiated.
Verified. When you look at this, I think we all know that things are controversial. And we could talk about the fiduciary rule coming now out of the Department of Labor. I mean, I could probably give you the top 10 most controversial regulations making their way through the regulatory body. But underneath all of that is a tremendous amount of regulation that goes on that is, you can argue whether it's necessary or not, but it is critical that we have agencies that are able to do that work in a timely fashion to give the certainty to the constituency stakeholders that they need in order to function. And one of the problems that we have is we react to things like the waters of the United States. We react to CO2 regulation in a way that then gives broad brushstrokes that may in fact have stopped us from moving forward and giving predictability that we would otherwise have. Do you see what I'm saying? We take the controversy and we redesign the system to deal with what's controversial, and that may in fact put too much onerous burden on the everyday regulation that has no controversy. And I guess I'd like to hear your response to that, Mr. Levin.
Well, I agree. I think that was implicit in some of what I was saying to Senator Portman, that one can look at particular areas and say there's a special need, but if you extrapolate it government-wide, you will be affecting functions that weren't really that controversial, but that Congress has said should go on. And adding procedures on such a broad basis can weigh down the process in that way.
And Mr. Grossman?
I agree with you. I would also add that, a lot of uncertainty comes in areas that can be resolved by agencies. You noted, for example, the Waters of the United States rule. If EPA and the Army Corps of Engineers wanted to, they could write a rule tomorrow that would win 9 votes on the Supreme Court, and it would be, relatively speaking, a pretty easy thing to do. What happens is that they have policy interests that are not necessarily compatible with the different views that have been expressed on the Supreme Court, and that's why you have the uncertainty and the complexity in that area. And I think in some cases where agencies are really trying to test the very, very limits of their statutory authority, and in some cases while disregarding traditionally understood limits on that authority, that's when you wind up with a lot of uncertainty in major areas.
Right, and it goes to my argument, which is Congress needs to take responsibility for assisting in determining what Congress needs to take responsibility for clarifying ambiguity in things that are as controversial, I think, as CO2, as controversial as waters of the United States, maybe the fiduciary rule that's coming out of the Department of Labor right now. And when we don't do that, that just becomes an invitation for further expansion of agency authority. When we don't act effectively, we're basically writing a blank check. And so the only entity, in my opinion, that can fix a legislative problem from the agency is Congress. And by putting too much responsibility on the courts, because maybe we think the political solution is too tough, we're abrogating our legislative responsibility, not just to the agencies, but also to the judiciary. And you made a great point, I think, Mr. Grossman, when you started out, because you talked about judicial activism, which for years was a buzzword, saying, they have too much authority, they're being too interpretive. Now we're talking about executive agency activism, and the real problem is legislative inactivism in helping resolve a lot of these controversies, it seems to me.
I don't disagree really with any of that. Congress really should be the first mover in pretty much every instance, particularly when you're dealing with major questions. That said, one point that may get overlooked in this discussion is something that economists refer to as the endowment effect. It matters who has a right to begin with. And so when we're starting now where we are, where we have a large body of laws, many of which contain very capacious language of delegation and authorization, under our current systems of deference, the agencies view themselves as being the ones with that first mover ability because they operate under this very broad, unbounded language that's only limited by sort of traditional and settled understandings rather than necessarily clear statutory barriers. And when those understandings fall away, the agencies view themselves as having a great deal of authority that Congress may well never have intended. So that's the endowment they have. And yes, you're right. Congress certainly can, in some instances, I mean, technically speaking, constitutionally, in every instance, reverse those decisions. But the problem is there are enormous hurdles and veto gates that make it very difficult to do that when agencies start with that endowment. I mean, it matters who has what at the, at step zero.
Let's stick with the waters of the United States example. So now you have this controversy. The regulation is moving forward. It's at OIRA, I believe, and so we're waiting. I don't think Congress should wait. I think Congress should play a role in making this determination. But when you say, so now let's say the court, instead of issuing the opinion that they issued, said, okay, hold off. We aren't going to, you can't do anything, you can't interpret this until Congress interprets it. In the meantime, I have a farmer who wants to tile their land, and they've applied for a permit. Or they need to know if they have to apply for a permit. And so in the real world, I'm saying, in a theoretical world, that's fine, but these regulations have practical effect. Every day, and to say we're simply going to stop, and I think the court would say that. We can't just stop and say put everything on pause because we have real practical applications. Let's take King v. Burwell. So what happens if the court says we're going to stop until Congress acts? That creates a tremendous amount of uncertainty to the folks who are on, who have gone to the exchange. That's a federal exchange and have relied on the tax incentives on that exchange. And so I guess my point in this is that theoretically, where I've been arguing Congress needs to act, it also is probably not a path forward for what I would call a stay of any executive action pending the Congress doing its due diligence and fulfilling its responsibilities has huge impact in the real world.
And I don't want this comment to sound overly critical, but it is a fact that Congress has been much less productive over the past several years.
That's okay if you're overly critical. We are too.
And very well. But it doesn't need to be, because I could just make the descriptive point that when you have the last two Congresses at historic levels of non-activity, the most passing fewer laws than any other Congress in recorded history, it puts a great deal of pressure in effect on both the executive branch and the judicial branch to see if they can find ways for the government to go on and do what it needs to do and fill gaps. But the upshot was that the agency had and has a program that it's been told to implement.
Well, I mean, if you take my example of King versus Burwell, I mean, if the judiciary decides we're tired of patching this together, what happens?
Well, I think King versus Burwell is really a very troubling case. I mean, it's troubling, first of all, in its implications, and I think everyone should acknowledge that, if people, who do depend on exchange subsidies lose them, that's, if that happens suddenly, that can have real world consequences. But it's also troubling because the way we got into this area was that the agency, by interpreting the law in a very implausible manner, changed the facts on the ground. In other words, it acted aggressively, and the result was to put us in this bind where if the court decides it a certain way that is probably the most natural reading of the text, there will be dislocation and consequences. And I think that's really an example of where we wind up when you have excessive deference,
Right.
That agencies feel that they're able to do that.
And the court doesn't live in a vacuum. I mean, the court understands real-world implications of their decision-making. It's not, I mean, they are not going to not consider the actual consequences. But I think it's going to be a very interesting decision.
Well, I think it is, but could I also add that I don't agree with the proposition that the position the government took was implausible.
Yeah.
I think they took the position that they believed with great conviction was intended by Congress all along. And if it is the case that for the Supreme Court to adopt Mr. Grossman's reading would cause great disruption, that seems like a good reason to believe that the IRS got it right, because it would be disruptive to have the world the way that the challengers are urging.
And we should acknowledge that there is a split in the circuit on the actual interpretation of that statute, not just agency interpretation.